Christopher Lee Collins from Labette County, case number 125319. Counsel, if you would please come forward and announce your appearances.
Good morning, and may it please the court, Christopher Collins appears through counsel, Casper Shire, Kansas Appellate Defender.
Good morning. May it please the court, Assistant Solicitor General Tyler Winslow appearing on behalf of the state of Kansas, the appellee.
Mr. Winslow, what's your bar number?
29432, Your Honor.
Thank you. Okay, you may proceed.
Thank you, Your Honor. And could I please have 3 minutes for rebuttal?
You may.
Chris Collins faced a years-delayed Jessica's Law accusation unsupported by physical evidence. Now, on its own, that's not a unique situation. And in fact, there's a fairly well-established prosecutorial playbook for these kinds of cases. Here, 3 witnesses took the stand in the state's case to talk about allegations that Carly made against Chris in 2017. Carly is a pseudonym. The state's case also included a video interview where Carly made those accusations to one of those police detectives. And the state closed its case by putting Carly on the stand to make those accusations herself. The theme of the state's case became that Carly had been consistent in her accusations since 2017 and that she had no motive to fabricate. What separates Chris's case from a lot of similar ones is that Chris tried to turn that playbook against the state, and he wasn't allowed to do it. He wanted to impeach Carly with a prior inconsistent statement made to law enforcement in 2016, a general denial of sexual abuse.
Was it really a general denial, though?
Yes, that is exactly what counsel proffered to the court in a number of different ways.
So my recollection or my reading of the record, when I look at that police report, that is specifically tailored to an investigation involving her father. And Christopher Collins is not Carly's father, correct?
No.
Okay.
And that's how the incident starts. But where it starts and where it ends are 2 different things. At the end of the accusation, I'll quote the last paragraph of the police report that was proffered to the court. This is the officer who responded to what was essentially a custody dispute at a Burger King to greatly summarize things. I returned to the station and read Grandma's statement. Grandma was the one pushing some of this, which becomes important as well. In her statement, she is stating that she is worried about sexual abuse of Carly. Carly was asked several times by me and did not include any abuse. I did not find any cause of concern or reason to remove the children.
But isn't that the tail end of a report where Officer Sue was dispatched to speak to the children about not wanting to go home to their father? And Carly was asked if there was any abuse in the home. She says no. The officer again asked Candy if her dad was abusing her. She says no. So consistently throughout this report, this is tailored to the father. But it's your assertion that then it becomes a general denial by the simple use of the word any.
No, there's much more than that, showing that this is a general denial. One, that is clearly how the defense proffered it to the court, and that's what they were going to ask Carly about. And the court recognized as much on Volume 7, 169. The court said, what I'm hearing state is that the witness has made a general denial and the defense wants to impeach with that. What's your response to that? So the court recognized that the defense was proffering a general denial, and that's what they were going to ask Carly about. 2, you have to look at this situation in the big picture, because this was not a standalone, one-off, no sexual abuse took place. 2 days after this happened, a social worker went to Carly's school
And let me interrupt you. 2 days after this, you mean this being the interview with the officer?
Yes. And asked, obviously, whoever was in charge of looking into this felt like it merited follow-up. A social worker went to Carly's school and asked her if she had ever been sexually touched. And Carly said no. So,
in that statement, that one I would agree with. That one I could get on board with as being a general denial. But this other, from the police report, I'm having trouble seeing where the district court got it wrong when it found that it was unrelated to Mr. Collins. And maybe that's just a factual disagreement that we have.
well, what was proffered was a general denial. That's what's in the report. That's what defense counsel said he wanted to ask Carly about. How Carly would have responded, we don't know, because defense counsel never got the chance to ask.
But that one's not a general denial, I guess is my point. The social worker, which they did have the opportunity to put on the stand and have testified that she did deny that, and that I understand. That's a general denial. But when you're taking a simple statement as a summary statement at the conclusion of a report tailored to the father, that does not seem to be part of a general denial. So I see a split. One came in as it should have, and the other did not for very good reason, because it's not connected to Mr. Collins, other than the same victim.
But a general denial is inconsistent with a specific accusation.
Right, but this isn't a general denial. The police report is a general denial that the father abused her. The general denial happened when she was asked by the social worker, have you ever been abused? And she said no. That's a global statement.
But that's not what's in the report that's proffered. What's in the report that's proffered is after they left the Burger King, there was a report of sexual abuse. A police officer followed up on it. Carly said no. Then a social worker followed up on it, asked her, hey, is there any sexual abuse happening at all? Have you ever been sexually touched? And she doubled down on that. She said, no, I haven't. Looking at the broader picture here, this is not a one-off general denial of sexual abuse. It's a pattern of denying sexual abuse, not just from her father, but at large, denying that anything ever happened. And that's inconsistent with what she said at trial.
Counsel, could I ask you to jump ahead to another issue, given the time constraints, to talk about the multiple amendments to the charging document, please?
Sure. These kinds of issues, again, come up a lot in these kinds of cases. And this one, to me, is unique. I think it crosses a line, because we were originally set to go to trial in 2019 on a date range charged basically the entire year, the calendar year of 2014. And when the parties show up for trial, the state says, look, we just learned that date is obviously incorrect. We can't go forward on this complaint. We need to amend it. Defense says, well, we were prepared to defend that date. That's unfair. We're not ready to defend a new date range. So if you're going to change it, we need a continuance. Lots of things happen in the interim, which are not Chris's fault and probably not the state's fault either. Number one is COVID, obviously. So we don't end up getting back to trial until several years later. After the state has finished their evidence, but before they rest their case, they say, you know what, we want to amend back into some of that 2014 date range that we were desperate to get out of before and that we delayed trial to get out of. And they're allowed to do it over defense objection. And that prejudiced not only Chris's right to a speedy trial, but also to due process.
But his defense was a general denial, was it not?
Well, it was, but he also said before the original trial in the 2014 date range, hey, we've got our defense prepared for these dates. State says, well, those dates are obviously wrong. We're not going forward on those. He's not going, he's not going to be prepared to present that defense at a second trial.
But he had originally prepared that defense.
That's what defense counsel said at the time of the first continuance, yes.
So where's the specific prejudice, other than, we were prepared for these dates, now it's these dates, but it's still a general denial. He just didn't do it ever. So how can you show prejudice?
First of all, I don't think I do have to show prejudice. I think the state needs to prove that it was harmless beyond a reasonable doubt. Second, he already gave up his right to a speedy trial to accommodate the state's need to, or the state, a better way to say it is the judge sacrificed Chris's right to a speedy trial to allow the state to amend into this new date range. So he's already suffered prejudice by the time he shows up for trial. Well, it's actually trial number 3 because there was a mistrial in the interim as well.
Wasn't there a waiver in there of mistrial because counsel wasn't going to be available, his counsel wasn't going to be available, so they had to bump it 3 months and he waived a speedy trial? There was a voir dire issue at the second trial. One of the panel members worked in the jail and said something about, I don't remember exactly what she said, but it was something about working with Chris in the jail or something to that extent, and that caused a mistrial. So I'm not necessarily throwing that on the state, but it's certainly not Chris's fault either. And I don't think he waived it. It was just something that happened.
Wouldn't we normally apply an abuse of discretion standard to this type of claim of error?
Yes. But Chris's speedy trial rights and his due process rights, his rights to know the date range that he's facing, particularly after he's been told, look, we're not going to pursue anything in this 2014 date range after he shows up for a trial on that date range. That's what makes this different.
Do you want to address the prosecutorial error argument at all?
I do. What the state said essentially was, why would Carly make this up? What evidence is there of that? That's burden shifting.
Or is it just going to attack her credibility?
Well,
how is it burden shifting?
I think the second part of the statement, and look, the case law on this says that you're walking a fine line when you get into rhetorical questions about witness credibility and motive to fabricate. And this crosses the line for 2 reasons. The first is the second part of that statement. What evidence is there of that? That suggests that if Chris wants to show that Carly is uncredible, he has some burden to prove it up, which he doesn't. And 2, this wasn't a one-off statement. The state came back to similar statements at least 3 more times over the course of its closing. And under the facts of this case, it was particularly unfair because the state knew that there was motive, that there was evidence of a motive to fabricate, and it fought tooth and nail to keep it out. That was the impeachment evidence that we started by talking about. The evidence there was that Grandma was driving a lot of the allegations, including the allegations of Dad and allegations of sexual abuse. That stayed on judges' chambers as a proffer, and then the state used the lack of evidence to say, hey, where's the evidence that she's fabricating? So they fought to keep it out and then used the absence of evidence against Chris. And that's particularly unfair.
And again, you would argue that it's the state's burden to prove it's harmless beyond a reasonable doubt.
Yes, and particularly when we have errors in multiple errors stacking up, the cumulative effect of those errors starts to add up, and the state needs to prove that not just each error is individually harmless, but together that they're harmless, and they can't meet that burden.
Do we have, I'm going to shift issues on you again. On the 6455 issue, do we have a preservation problem?
Well, the Supreme Court decided, or there was a Court of Appeals Sheets case. I filed my brief, and then there was a Supreme Court Sheets case. So I made my preservation argument, obviously, based on the Court of Appeals Sheets case. I don't think my preservation argument changes because the facts are the facts. I'm not going to stand here and say that the Supreme Court Sheets case doesn't change the way that you on the bench have to look at it. But my fundamental argument is the same, which is that, counsel argued that this has to come in through 6455B rather than 455D, which implicitly says, hey, this isn't 6455D evidence, which is the argument that we're making. I will say I don't think Sheets affects the preservation of the second part of the analysis at all, which is the prejudice versus probative piece of it, which was also preserved and litigated.
You have 1 minute remaining if you would like to just tag that onto your rebuttal, or you can do a summary.
Sure. Impeachment evidence is not all impeachment evidence is created equal. Some impeachment evidence is more powerful than other impeachment evidence. One denial is not the same as a pattern of denials, and it's certainly not the same as a pattern of denials that also provides a motive to fabricate. Here, the state's case did not have to survive the full crucible of cross-examination because Carly didn't have to face some of her prior inconsistent statements. The only way to know what a jury would have done if the state's case had been forced to survive the full crucible of cross-examination is to send this back for a new trial. And that is what we are asking this court to do. Thank you.
Good morning, Your Honors. Procedures. The state agrees with the appellant insofar as this case ultimately boils down to procedures in a child sex case. The general roadmap for how I'm going to take these arguments is actually out of order from how they were briefed and how they've been discussed today. But first, I'll address the complaint. Then I call her KP. That's how I always read the briefs. So that's how it is in my mind. Then I'll take on the 455 evidence and the prosecutorial error. Ultimately, I plan to stand on the briefs with respect to cumulative error and the criminal history score calculation pending for the questions by the court. With respect to the complaint, there are actually a total of 4 complaints, 3 amendments from the initial charges. And as initially charged, the allegations would have occurred between August and November of 2014. The first amended complaint then broadened that to January to November of 2014. The third complaint is where the 2011 to 2013 calendar years came in, and then ultimately to conform to the evidence presented at trial is where we get from 2011 all the way to May of 2014. Breaking these down, there are really two amendments, and the analysis is separate for them. The 2011 to 2013 amendment can't have any prejudice on Collins' substantial rights. The reason for that is the new preliminary hearing and ultimately the case proceeded to trial as timely as possible given the circumstances. To include a mistrial, to include COVID delay. There's just no speedy trial violation, and there's no prejudice. There's not been any assertion that a witness was lost by the time, that Collins' defense was anyway inhibited by that delay, that there was something lost. Secondarily, the amendment to conform to the evidence at trial. Ultimately, I'll turn to Collins's defense. He called KP's dad to talk about a broken window because KP's testimony was tied to this broken window. And Collins's defense was, well, the window was actually broken 2 years after even the amended allegations. So there just is no prejudice even with the trial amendment. Next, with respect to the impeachment evidence, the district court properly analyzed the statement to Officer Sue, the November 6th, 2016 statement, properly analyzed it as a specific instance of misconduct because there were allegations against KP's dad at that point at trial. Those had already been made. And so that is potentially a specific instance of misconduct as KP later came forward with allegations of abuse against her father. However, under 6421, the only way to get a specific instance of misconduct like that into evidence as an impeachment is for a conviction to have occurred, and no conviction had occurred. So ultimately, the district court was correct in its analysis.
But do you think the district court viewed it as a general denial?
No, I do not. Not with respect to any sexual abuse. And that's the distinction between the November 6th and the November 8th statements. The November 6th statement, we have the Burger King incident. We have grandma involved. We have everything wrapped around KP's dad. It is really the source of those allegations.
Because grandma's concern was father was abusing her.
Yes, Your Honor.
Not that somebody else had been.
Yes, Your Honor. And that's what that police report, that's what that indicates, is everything KP discussed with Officer Sue was related to her dad. And so absent some broadening of those questionings, and that's just not in the police report, to KP's statement can't be a general denial of any sexual abuse by anyone at that point. Now, the social worker's question obviously correctly allowed as impeachment evidence as a general denial in the face of specific allegations. And turning then to the harmlessness of it all, the would-be impeachment and the actual impeachment are only separated by 2 days. There's this argument that it would have been an impeachment stacking, but this is 2 days apart, and so it seems that there wouldn't be much of a greater effect had they been together than had they been separated as they were.
So as to harmlessness, when I look at your brief, and you can correct me if I'm wrong, it just seems like you included it in one sentence.
I'd agree with Your Honor.
It seems to be a waiver of the harmlessness argument.
I agree, Your Honor, insofar as the brief is written. The brief itself is fairly perfunctory as to the harmlessness analysis.
It mentions what you just mentioned.
I'd also agree with that, Your Honor.
It says something general like because the victim was impeached and the jury still found the defendant guilty, that means it's harmless. I believe that's what the sentence.
Yes, Your Honor, and this would be a distinct argument. I'd recognize that it's as not briefed before this court is the way I just characterize the argument, I think. So, turning then to the 6455, the state's position here is that there is a preservation issue for the statutory interpretation of 6455. Really, it's 6455G that lists all of the other sexual misconduct that can be included. That argument wasn't preserved before the district court. Even if it was, it does seem that the Missouri conviction would fall into 6455G10. It's kind of that catch-all provision for other jurisdictions. But even turning then to the rest of the analysis, we do agree with the appellant again that the statutory interpretation analysis, while not properly before the court, the remaining unfair prejudice and relevance analysis is before the court. And insofar as the conviction is clearly proven, we had the records admitted at trial, and Collins's guilt, to include the propensity inference that is authorized under 6455D, ultimately was part of the proof for trial, and it was a hotly contested issue. You had the general denial all the way down to KP can't have been correct, at least on the dates, and I think the defense was really, this just didn't happen, boils down to the Missouri conviction helping the state's case, which is what 6455D is meant to allow. I'd also note that in Boysaw, which the district court specifically relied on, the court was dealing with a 26-year-old conviction. So Collins' 30-year prior conviction, not significantly different in the state's view. And finally, with respect to the prosecutorial error claim, why would KP make this up? Was a proper argument, generally citing to State v. Jordan.
But this isn't Jordan. And I will tell you, counsel, I am very much on the fence with this issue, and I'm hoping that oral argument will help, because this is not Jordan. In Jordan, this was very closely tied to the facts, and what I see in this case is counsel just hammering away at the credibility angle of this. Why would she make this up? What reason does she have to say this? Please help me understand how this aligns with Jordan, because I don't see it.
In my reading of Jordan, I'm looking at the specific portions that address all of the factors of credibility, which is in context what this prosecutor's argument was doing. We start with the difference in time, the delayed nature of the report, and then getting into the invitation to examine KP's credibility from the position of a motive to fabricate. I'd also add that the articulation that grandma was somehow the motive to fabricate in this case is not what the proffer was. Insofar as those two issues would be related, they're not. The proffer was specifically about the general denial. That's a different, what I would call a silo of attack in terms of credibility, because the district court was not asked, can we ask about grandma getting her to make this allegation, grandma being the impetus behind the 2016 statements. Ultimately, both of them, from the state's reading of the record. And so highlighting for this court, I would just point to the context of the oral, to the argument as a whole, discussing KP's credibility, which is what Jordan stands for insofar as the argument is proper.
So it's your opinion that the record will stand for the proposition that every time that the comment was made about her credibility, it is distinctly linked to the evidence? Or why, whether I use credibility, or why she has no reason to make this up every time that phrase of that nature, some iteration of it is mentioned, it is always linked to the evidence.
The evidence is KP's testimony, the entirety of that testimony. So in discussing KP's credibility, that is linked to KP's testimony. So yes.
What if we presume that we find error? What's your best argument on this is harmless beyond a reasonable doubt?
Ultimately, the jury I'd highlight, as almost always with these claims of error, the jury instructions. Counsel's statements are not evidence. They are to help you understand the arguments presented. And then I'd also turn to the 6455 evidence, the Missouri conviction, as well as all of the jury had KP's statements in totality to examine. So in total, for this court's consideration, I would point to the evidence that the state did present, as well as the district court's instruction. pending further questions from the court, I cede the rest of my time and just ask that the court affirm.
Thank you. You'll have 4 minutes, Mr. Shire. You have 1 minute.
Thank you, Your Honor. And maybe this is ambitious, but I'm going to try to hit 3 things quickly. First, on the impeachment, there's no way to separate the November 6th denial from the November 8th denial. The November 8th denial never happens. That meeting at school never takes place without what happened on November 6th at the Burger King, without Grandma calling police to make accusations which end up being unsubstantiated against Father, without Grandma trying to manipulate Carly's answers to police as she's asked about, possible abuse, and without Grandma saying, hey, I have these concerns that Carly is being sexually abused, and an officer following up, asking Carly if she has been sexually abused, and Carly saying no. That's the whole reason we have the November 8th denial in the first place, and that all has to be fair game for impeachment. 6420 says anything that goes to credibility comes in, and the court erred as a matter of law by not letting it happen. Second, I want to turn quickly to 6455. In doing the prejudicial versus probative analysis adverse to Chris, the court didn't just rely on Boysaw. It said that it found itself bound by Boysaw. And that is not right. A district court is never bound by what a separate district court has done under, a similar factual situation. But the other problem with that is Chris's case, there was a major difference between Chris's prior and the prior in Boysaw, which the district court did not address, which was Chris's age at the time of the prior. He was a teenager. So it wasn't just that it was old.
Was he a teenager or was he 18?
I'm not sure that there was ever a definitive answer to exactly how old he was. He may have been 18, but there's still a big difference between an 18-year-old committing an offense against a child and a much, much older man committing an offense against a child, and that didn't get taken into consideration at all, as I see it in the probative versus prejudicial vein.
The victim in that case was under 12 or under 11?
I believe the statute required under 12, but I'd have to double check that. The complaint is in the record, so it'll speak for itself, Your Honor. Finally, on prosecutorial error, Jordan was a close case. I think Jordan itself said that the facts of that case, I think, teetered on a line of error is the language that they used. And I think this court is absolutely right in noting that the state went further here. They went harder and more often than the facts we see in Jordan, and that has to be that crosses the line. And it denied Chris a fair trial because he didn't have the opportunity to meet the evidence, to meet the theory that the state unfairly advanced against him, which is that Carly had no motive to fabricate here, and that he was supposed to put on something to show that she was. And that's not a fair trial, and we ask this court to reverse and make sure that he gets one.
Any further questions? Thank you.
Thank you, Your Honors.
Thank you to both counsel. We will take the matter under advisement and issue an opinion as quickly as possible.